Hello, good morning, everybody, and welcome to Sunday Fun Day from Courtroom Confidential, the fastest true crime news channel, the fastest growing true crime news channel on YouTube. Happy Mother's Day, everybody. What a fun Sunday that we get to spend a little bit of Mother's Day with you. So happy Mother's Day to all the mothers out there, all the grandmothers, all the dog moms, all the cat moms, all the bird moms, and even all of the horse moms. That's a shout out to you, Afton. Thank you, everybody, for being here. Appreciate that you were able to carve out some time on your Sunday to spend with us, and this is going to be a good one. So hello to Jersey Tomato, and to Debbie Blair, and to Elizabeth, and to Martina, and Alicia K. Mayo, and June, and Shy Gal, and Afton. Thank you, everybody, for being here. So, for the new folks, my name is Joshua Ritter. I am a former LA County prosecutor. I was there for about 10 years, and then I left the office, went into private practice as a criminal defense attorney, which is what I do now. This is, of course, Courtroom Confidential, where we do our level best. Our mission is to present to you, both sides of the courtroom, try to give you an objective perspective on both sides of the courtroom, and we hope that we do that. And this, of course, is Sunday Fun Day, where we take your voice messages that you've left over the last week, and we're going to answer them live today. And there are some really good ones. And we've got calls from all over the place, and we're going to put them all on the map. And we're going to send happy Sunday and happy Mother's Day wishes to everybody, including Susan D. Thank you so much for being here. And you guys showed up. Yeah, guys absolutely came through with all of the messages this week. So I'm really excited to get into them. Let's just go ahead and start jumping in, because we've got a bunch of them, and I want you guys to be able to get on to whatever Mother's Day festivities that you have planned. All right. And here's where Josh has to start doing stuff. All right.
Hi, Josh. This is Pam from Michigan. I've already submitted a question this week, but I have another question. I've been listening to this week's Karen Reed trial and was wondering, for Jen McCabe as a witness, seems like she's not a very good witness for the prosecution. It seems like she's inconsistent. Some of the questions that Ellen Jackson was asking her about why she didn't go into the house, about her statement changing. Could this be a problem moving forward for the prosecution? Is this something that could impeach her as a decent witness? Is it something that that she just doesn't seem to me like she would be a really good prosecuting witness? And it seems actually like she could be almost a hostile witness, because the way she's answering some questions and not answering some questions. So just a thought. Hope that made sense. It's kind of more than a few questions, but thanks so much for answering all these. I always love all the group questions on your Sunday program. Some of the same questions that I have. All right. Have a great day. Thanks.
Thank you so much, Pam, for kicking us off. First of all, let's make sure that we put Michigan on the map. Thank you for calling in. Lots of Karen Reed questions this week. Karen Reed is on people's minds because we've been watching the trial. Alicia K says, great question to start us off with. I completely agree. And if you're watching the trial, the place you should be watching it is over on Courtroom Confidential Live Trials, where we've got a wonderful chat going over there. And, a lot of interesting developments this week. And Jen McCabe, I think was she this week or last week? I don't know. Everything's melting together. Everything's becoming one big blur. But there she is. Obviously, one of the pivotal witnesses for the prosecution. She is one of the ladies that was with Karen Reed that morning when they found John's body. She's one of the people who says that Karen Reed says, I hit him. We're talking about John O'Keefe. So obviously a very pivotal person and she is the person who logged in her phone, the Google search for how long to die in the cold, which is a point of contention because it all depends on what time she made that. Big difference if she made that at 2:27 in the morning or if she made it sometime after 6 and John's body was discovered. So Pam asked the question, how did she do? Or not, that wasn't even really the question, is she a problem? Because it seems like She didn't do that well. Here's some thoughts on this. It's so funny to me. This case is so wild, and every once in a while you'll see a case like this where we have the benefit of kind of having the public forum in front of us at our fingertips with Twitter anymore. But you see a person like Jen McCabe testify, and you've got a bunch of people on Twitter who are like, oh my God, she fell apart. Alan Jackson ripped her to shreds. She's a complete liar. And then you've got another contingent of people who are just as vocal saying, wow, she really handed AJ his own butt. She did well. She answered every question. She was fantastic. And so it's kind of hard to get a objective perspective on the thing. And I'll admit, I watched the first trial. I've got, I'm not going into this like a robot, but I will say this as kind of objectively as I can, just calling balls and strikes. I will say one, that she did, I think, better than she did the first time around. I think she was less hostile than she was the first time around. She was probably more prepared for Alan and his aggressiveness this second time around. She seemed to kind of keep her composure, but this jury doesn't have the benefit of knowing how she did the first time around. So that's really not helpful for what the jury is thinking. Here's the thing. It is hard for anyone to stand up under cross-examination from a very skilled attorney like Alan Jackson. I imagine if Alan were cross-examining me, I would have a tough time telling the truth about everything. What I'm saying is, even if I'm telling the truth about everything, a very skilled attorney like Alan can make it sound like things are suspicious and you're not telling the truth and you've told different stories. And he would make great he would make incredible points with even the smallest of things. And if you watch Alan, this is something that a lot of people I don't hear talk about, but he's very skilled at this. Alan will take 4 or 5 questions, which last several minutes, to build up to one crescendo question. He'll do, didn't you testify before at a grand jury? Yes, you did. And you testified about the things that you're talking about here today. Yes, I did. And that was under oath, correct? Yes. You swore, you raised your right hand, swore an oath to tell the truth, correct? Yes. And you were telling the truth back then. Yes. And you are swearing to tell the truth here today, and on and on and on and on and on to go. But you told the grand jury X, Y, and Z. And here today, you're telling us A, B, and C. And it builds up to this incredible point. And I applaud him for that. And that's why he's very skilled. But depending on how you feel about this case and maybe some preconceptions that you bring into it, you might feel very differently about how she held up under that or how she did not hold up under that. I will say this. I think she checked off all the boxes that the prosecution wanted her to check off. And I think Alan got all of the points in cross-examination that he wanted to get out of it. Did that actually move the needle all that much with the jury? Well, I think it's going to come down to a lot of other things. It's going to come down to which experts do they believe about when that Google search was made. It's going to come down to, do they believe Jen McCabe and other witnesses as far as what Karen Reed was saying that morning? So, I don't know if I'm giving you the greatest of answers, Pam, but I don't think the entire case, though she is a pivotal and central witness, I don't think the case rises or falls on her. And I don't think that either side really came out of that thinking they had a crushing win from how that went. But now that I've even said what I feel is like the most balanced answer to that, I'm sure it probably got a lot of you hot under the collar. But great way to kick us off, Pam. Thank you so much. All right, let's move it along here.
Hello, Josh. This is Nancy from Rising Sun, Maryland. And my question is, whose duty is it to put forth a perjury accusation, and what is the penalty? I'm watching the second Karen Reed trial, and Jen McCabe's testimony is varying from the first trial. She has the inability to say either yes or no. Everything is an explanation. Okay, thanks very much. Love your show. Bye.
Thank you so much, Nancy, calling in from Rising Sun, Maryland. Let's put her on the map. Again, Karen Reed, Jen McCabe. We're going to have a lot of these this week. That was a big development since we did our last Sunday Fun Day. Well, one thing that you brought up right at the end there is talking about how it seemed as though Jen McCabe had the inability to give a yes or no answer. And that is funny because when you're doing cross, all you want are yes or no answers, right? You're trying to really steer someone down a very specific path, and you can only do that if they're giving yes or no answers. And if they're not giving yes or no answers, that can frustrate the attorney. But the question is it frustrating the jury? Is the jury interpreting that as she's being evasive? She won't answer anything. She can't give a straight answer. Or are they going to interpret that as, you know what? She's picking up on the nuance of his questions, and maybe some of his questions don't give a yes or no answer. I will say this. When I, and still now, but when I was a prosecutor especially, I would tell witnesses, just answer the question. I don't need you to fight. I don't need you to advocate. That's my job. Let me do my job. You just answer the questions. And I'll be honest with you, I don't really care about the questions and answers because I get to come up on redirect and clear all of that up. So don't feel like you need to get into a back and forth with the attorney. I guess it's up in the air as to whether or not Jen McCabe actually did that, but I did notice that she was far more careful and far more attentive to Alan's questions this time around. And I know we're doing a lot of comparison from the first and second trial, but, I think, again, it's hard to see what the jurors are viewing this from completely brand new eyes, never having heard it all before. But you can certainly see that many people feel very differently about how Jen McCabe performed. But thank you again, Nancy from Rising Sun, Maryland. All right, let's keep it going. Let's see what any wild guesses what our next question is going to be about.
Hi, Josh. This is Kim in Gilbert, Arizona. I really enjoy your What's Happening section after you talk about each case. My question is, defense attorneys, do they really convince themselves that their clients are innocent in order to defend them? Or do they really know that they're not and they just have a job to do? For example, I can't believe Alan Jackson and his partners all believe that this wasn't an accident, that she hit him, because so much science now has negated the third party culprit theory. Thank you so much.
Thank you so much, Kim from Gilbert, Arizona. Lovely place, Gilbert. I think I actually have family who lives out there. I don't know why I'm not certain of it, but I believe I've been to Gilbert, Arizona. Beautiful place. Karen Reed again. Karen Reed causing trouble this week. Excellent question, though, Kim. Do defense attorneys really convince themselves that their clients are not guilty in order to defend them? What Kim is asking is, do defense attorneys ever get high on their own supply? And the answer to that is, yeah, maybe, I think. I think that sometimes when you are advocating so zealously on behalf of someone, and you are so entrenched and embroiled in the arguments, I think sometimes you do convince yourself. Now, that doesn't mean that every defense attorney has been, every defense attorney only believes in the innocence of every single client they've ever represented. That's just not true. The defense attorneys, believe it or not, are human beings. And myself, I have represented people that I do not believe in their innocence. And you're doing a job, though. Your job is not necessarily to prove their innocence. Your job is to show that the government has not proven their case beyond a reasonable doubt. Is that splitting hairs? Not really. It's actually a huge distinction and very important. The burden rests upon the prosecution. My job is to show how the prosecution has not met that burden. My job is not necessarily to prove the innocence. In fact, it is absolutely not to prove the innocence of my client. But in many cases, I do believe in the innocence of my client. I have represented people who I absolutely believe did not do what they are accused of. Now, there's a lot of gray space in that, right? There's people who are accused of something awful, and I think they didn't do that awful thing, but they may have done something. And then there's people who I think they just got the wrong person, or what they've accused them of, they just didn't do. But you're asking specifically, does AJ and crew that we see there in the picture, boy, that is a team of attorneys, by the way. What is that? 5 people. Are they high on their own supply? Do they actually believe in the innocence of their client? I cannot tell you how AJ feels about this case. I've never talked to him about this case on purpose, but I will tell you that he can understand when, if he feels that somebody's done something that does not change how many gears he throws it into if he's going to defend them. But at the same time, I think that this case, in Alan's view, if I'm just trying to read his mind, is much more about the failure of the investigation, and for those reasons, advocating for a not guilty verdict, than it is about everything else. And then you say, but why all the cover up and why all the conspiracy? And I think he would say, well, because it exists, because it's all out there. So I might as well show it to people. And if they feel that that played a role in all of this, then so be it. But I think they believe that she is not guilty. I think you might be right. I mean, they do seem, it's hard to tell. I don't think you would know the difference, I guess, is the answer, the best answer to that question. I don't think you would see any difference in the way that they represented her, whether they believed it or not. And that's probably, and in fact, that is absolutely the way it should be. But thank you so much, Kim from Gilbert, Arizona. All right, let's keep it moving along here. I don't want to lose my place. Hold on.
Hey, Josh, Redondo Beach here. Question for you on the Cellebrite expert. How was that even allowed in? Because he admitted he did not extract the phone, and he also couldn't sign off on the hash mark or something. It seemed like there was either no foundation, or if he didn't do those things, how can he be an expert? And if the defense had the competitor showing Jen McCabe's search at 2:27 in the morning as being at 2:27 in the morning, why didn't they call them?
Redondo Beach, calling from Redondo Beach, California. Thank you so much. Always good to hear from you. Karen Reed. Karen Reed apparently is on trial this week. Excellent question, though, talking about the Cellebrite expert. And I think Redondo's question is in calling this, what was his name? Ian Whiffen. If you're calling someone who hasn't actually done the extraction, how can you actually call that person? There he is. The answer to that is that's many times the kind of experts that you're calling. Many times you are calling an expert who has not done the original work, but they're analyzing the reports and the analysis of that work and giving their own opinion. You will sometimes, in cases, have a medical examiner who did not perform the autopsy. They are going off of the reports of the autopsy and the notes from the original coroner to give their own opinion as to the cause and manner of death. So not uncommon, in fact, very common for people to be called in as an expert to give an opinion and interpret evidence their own way. Which brings me to a very interesting point, and this goes back to this kind of 227 thing. I was having a conversation with Tiffany, T-Suze, who happens to be my wife, if you guys don't know. And we were talking about, she was saying something about, well, the evidence shows X, Y, and Z. And it was about the Karen Reed case. And I said, no, that's not the evidence, okay? The evidence is that there was a phone extraction, that there was a search for how long to die in the cold, and that there are certain timestamps associated with that can be associated with 2:27 or it can be associated with 6 something in the morning. That is the evidence. The opinion is which one of those is true. The expert's opinion, if you are for the defense, is that took place at 2:27. The expert's opinion, if you are the Commonwealth, is that took place after the discovery of John's body. Neither one of those, even though they're evidence in that they're introduced at trial and for consideration of the jury, they're both opinion evidence, which is a very different thing. Let's talk about the injuries to John's body. The evidence is that he had injuries to his head, injuries to his face, and injuries along his arm. That is the evidence. The opinion is that the injuries to his face and arm, according to the Commonwealth, were caused by a car. The opinion is that the injuries to his arm, according to the defense, were caused by a dog. And there's a very different, those things are very vastly different. And so I think it's important when we're having these conversations to really, appreciate a lot of that, even though it might seem like a simple point. Many times when we're talking about, well, the evidence is, or they've proven X, they haven't really. What they've done is presented with you expert opinions that can interpret this same evidence different ways. And it's going to be up to the jury, who is considered the finders of fact, to decide which of those two expert opinions are more reasonable, or which they can rely upon. Or they throw out both and decide that they can't decide. And then you've got a jury who doesn't feel that this burden has been met. So anyhow, Redondo, excellent question. It all boils down to, how do you interpret this evidence? I think it's remarkable to me, though, even something like digital evidence, where you would think it's all ones and zeros and we should have a yes or no answer, can come down to a matter of opinion. So great question, Redondo. Appreciate you. All right. Let's keep it moving on here.
Hi, Josh and crew. This is Afton from South Central Kansas. I was wondering if you could explain a little bit about how refreshing memory works by showing the witness documents. There were some cases during Jen McCabe's cross-examination that had me wondering. Thank you.
Afton, so good to hear from you. Always appreciate it. Always appreciate all your support and hard work for this channel. Calling from South Central Kansas, and happy new horsey in the family. Happy Mother's Day. Karen Reed, Jen McCabe. But this is a great question. It's talking about refreshing memory, and it's something that we may take for granted how this all works, but there's a very specific set of rules that attorneys must follow in order to properly refresh somebody's memory in court. And so that's why you will see Alan ask, and Brennan ask, very specific questions before they're allowed to do things. So first of all, there's two things going on here. What we're seeing a lot of is what's called past recollection refreshed, or refreshing someone's recollection. It's a Karen Reed Sunday, says Vesper. So you've got a witness on the stand. You must first establish that they at one point knew something and now they can't remember. So you can't refresh somebody's memory, and this might seem small, but it's important. You can't refresh somebody's memory if they say they never have known that thing. But if they're on the stand and they say, I can't remember, and it's established that that was something they knew at one time, then you can say, would taking a look at X refresh your memory? Would taking a look at your police report refresh you? Would taking a look at statements that you made during the grand jury refresh your memory? Would taking a look at anything? I mean, the law doesn't get specific. You can show them absolutely anything. Objects. In law school, they used to say you could put in front of them a plate of spaghetti if that will refresh their memory. The only caveat in all of that is that whatever you use, whatever you show to them, you have to then show to the opposition. So you can't get clever and write out the answer as an attorney and then hand it to them and go, does that refresh your memory? Because you're going to have to hand that over to the opposition. And usually what you see are police reports, prior transcripts of testimony. Now, the way that this drives me nuts is they're supposed to take a look at it and read it and then go, does that refresh your memory? Yes or no? And then they give the answer of, okay, how far away were you from John O'Keefe's body when you first saw him? I was 10 feet away. Here's the problem. Many times they're not having their memory actually refreshed. They're just remembering what they just read on a page, right? And they're putting faith in whatever they said before was correct. And you'll see them say this sometimes where they go, well, if that's what it says, would it refresh your memory to take a look at, would it refresh your memory to see your grand jury transcript where you said you were never told that? Well, if that's what it says, well, that's not really the question. We're not asking you if that's what it says. We're asking you if that refreshes your memory. An interesting thing about this is that you can put a screeching halt on this type of stuff if the witness takes a look at that item and you say, does that refresh your memory? And you go, no. Because they're still only supposed to be testifying to their memory, not to the hearsay contained in the piece of paper that they've just been handed them, because it is hearsay. You're showing them an out-of-court statement. If they say, no, it doesn't refresh your memory, then you have to turn to something else, which is called past recollection recorded. And this is a hearsay exception. So if you can again establish that somebody once knew something and now they can't remember it, that they recorded that thing when it was fresh in their mind. They took notes. They told, they recorded it, voice-wise. They told somebody else, and that accurately reflects their direct knowledge at the time of that thing. You can actually then have that piece of paper admitted as a piece of evidence. So somebody watches, some traffic accident, something horrible take place, and they write down blue car, white canvas top, and Arizona license plate. And you ask them, would it refresh your memory? Or did you record this? Did you write this note at the time? You can actually then have that piece of paper admitted as a document. And I know I got a little bit into the weeds on all of this, but that is why you see this kind of dance taking place. You have to establish they once knew it. Now they can't remember it. Something would refresh their memory. Ask them to take a look at it, not read from it, but see if it refreshes their memory, and then ask them questions about it. But all the time, you're supposed to be just asking them about their memory, not what's on the document. K9 Lover says, Jen McCabe was the queen of cross amnesia. Yes, she was. And she gave Alan some fits because of it. All right. Excellent questions, everybody. Let's keep it moving. Any guesses as to what our next question is going to be about? Oh, if I can get it going here.
Hello, Madeline from Denver, Colorado. I have been reading lately about this Colleen Ritzer case, which is from 2013 out of Massachusetts. She was a 24-year-old teacher who was murdered by her 14-year-old student. Very sad, and there's a lot of very sad details involved in that, and a lot of mental health involved in that. But my question is that I saw that the family, after the criminal conviction, the family filed a civil lawsuit against the architecture company that designed the school where she was killed. Why, and what's the basis for that? How could the family go after the architecture company? It just seems like a very big reach. Thank you.
Madeline from Denver, Colorado. We tricked everybody. You thought it was going to be another Karen Reed question. It was not. It was a case that, a really horrific case that I had actually not followed. I think I remembered when this took place, but I have not followed it since. Thank you so much, Madeline, putting you on the map. Denver, Colorado. So this involves, this was in 2013 out of Massachusetts, involving a teacher by the name of Colleen Ritzer. She was 24 years old at the time. And one of her students, whose name was Philip Chisholm, who was 14 years old at the time, barely a teenager. And the story goes that they're having some sort of discussion, and it comes up. Yeah, and this gets graphic, so just kind of prepare yourselves. It comes up that Ritzer somehow mentions that Chisholm is from Tennessee, and it's unclear if she says that in a way that's mocking to him or what. But in any case, she it sets him off. It completely triggers him. She does not realize this. She then goes to the restroom. The faculty lounge apparently was occupied, so she goes to one of the girls' restrooms. Chisholm enters in after her and proceeds to absolutely brutally kill her. He apparently assaults her sexually with an object, and then also slashes her throat and leaves a note next to her body saying, "I hate you all." He then leaves, and they don't see what's inside the restroom, obviously on camera, but they see cameras outside of the restroom, where he then goes and gets a recycling barrel, comes back into the restroom, and then he's seen dragging this barrel, which is obviously weighted down with her body, outside. Her body is discovered sometime later. He runs away. He's arrested with a bloody knife on him. Her body is discovered sometime later in a wooded area, and this 14-year-old man got 40 years for this. Just mind-blowing violence, horrible story. But what is kind of interesting, this was back in 2013. Since then, there's been the criminal case, and then obviously civil cases are going to take place. And one of the defendants in that civil lawsuit, as Madeline points out, and thank you for calling, Madeline, appreciate hearing from you, is why in the world did they sue the architecture company who designed the school? The reason for that, first of all, it's a Boston architectural firm called Danisco Design. The reason given in the lawsuit was that they felt that the security systems in place at the school were inadequate and that they were not working that day, and that in part led to her tragic death. Let me just give you some thoughts, but first say that it has since then settled. The lawsuit of her family with the architectural firm has since settled. It settled in 2022, and it was for an undisclosed amount. But you might be saying, how in the world does the architectural company share any negligence? And that's what we're talking about in a civil suit with any of this. Well, they actually tried to get the case kicked out on a summary judgment, and the judge kept them on as defendants. Apparently, there was enough evidence to keep them on. It's some sort of argument to be made. But the better kind of answer to all of this is usually when filing lawsuits, you sue everybody. You sue the faculty, you sue the administration, you sue the school district, you sue the designers of the building, you sue absolutely anybody and everybody. And that's not because you're just being wild. It's because you don't know how the case is going to work out and who might be negligent in all of it. And it could be that somehow the design of that school played a role in all of it. So you don't want to miss that. And obviously here, there was some sort of perceived negligence and enough for a settlement to arise out of all of that. But a very interesting kind of side question attached to a very tragic and awful case. And thank you, Madeline, so much from Denver, Colorado, for bringing that to our attention. And I appreciate hearing from you. All right, let's keep it going here.
Good morning, Josh. This is June from Stockton, California. I have 2 questions today, and hopefully I could do it in one recording. In February of 1972, the California Supreme Court ruled the death sentence as being inhumane and cruel. They reverted all death penalties to life without the possibility of parole. Why then was the prisoners for like Sirhan and Charlie Manson not reverted back to the original penalty of death when it was reinstated in 1977? And in November of 1977, the people of California also passed Prop 7 in regards to the death penalty. Question number 2, has there been any new information on the JonBenet Ramsey murder case as of today's date? Thank you very much. You have a wonderful week. Talk to you next Sunday.
June, thank you very much. Always love hearing from you from Stockton, California. Let's put you on the map. All right, get out your notebooks. You will be tested on this. Why in the world was Charles Manson, who was convicted in 1971 and sentenced to the death penalty, why was it that he was ever considered to be eligible for parole? I thought that's not the way it works. And you're right, June, that's not the way it works, but there's a long and twisted case law and legal reason why. So Manson is convicted in 1971, sentenced to the death penalty along with several other people. In 1972, California overturns the death penalty in California based upon a case called People versus Anderson. It was the California Supreme Court, where they felt that the death penalty was abusive, ran afoul of the California Constitution. Every state has their own constitution, and the California Constitution uses the language cruel or unusual punishment, which is very similar to what's in the 8th Amendment of the U.S. Constitution. But the Supreme Court felt that the death penalty was just unconstitutional. And therefore, everybody had their sentences commuted from death to life. Now, at that time in California, there was only the death penalty or life, not life without parole. So Manson was sentenced to life with the eligibility of parole. In that same year, there was the case, a Supreme Court case called Furman versus Georgia, where they found that based on procedural and due process grounds, there was problems with the death penalty. What basically happened in the early 1970s is that there was a lot of pushback and criticism of the death penalty, and the death penalty in many states went into this kind of moratorium period where nobody knew what to do because nobody wanted to run afoul of the Supreme Court. And so all these states were trying to figure out, is it constitutional or not? But the Supreme Court didn't actually say it was unconstitutional. It was just said that there was problems procedurally and due process wise with the death penalty. In 1972, the state of California, the voters passed Proposition 17, which actually amends the California Constitution. It passed by a 67% approval rate, allowing for executions in California, basically in response to the Manson case. However, because of all of this uncertainty, there were no executions actually performed in California until 1992, so 20 years later. In 1978, the California does adopt life without parole. Now, your question is, okay, why didn't then Manson get life without parole in 1978 if he was sentenced to death? They commuted it to life, and he obviously would have been sentenced to life without parole if there was not a death penalty in place. The answer to that is that sentences can be reduced retroactively, but they cannot be increased. So if you are in prison and they change the law so that whatever you were sentenced to, you can no longer be sentenced to that, They change the exposure on the crime that you're sentenced to. They can reduce your sentence, but if you're in prison for something and you've been sentenced to X amount of years and the state legislature decides to change the laws and increase the penalties against that same crime, you cannot now be retroactively have your sentence increased. And the reason for that is that a lot of this has to do with, strangely enough, notice to prospective criminals. So you should know that if you commit a robbery, you're looking at 2, 3, or 5 years prison. And that if you commit that robbery and you're sentenced to 5 years prison and they then change it to the max you could get is 10 years, you shouldn't be given that 10 years because you only thought you might get 5 if you committed this robbery. That is the thinking behind it. But if you are in for a robbery and you're doing 10 years and then they change it for everybody to be back down to 5, you're going to get the benefit of that 5. In other words, can work retroactively to reduce but not increase. And that's why Charles Manson remained in prison under a regular life sentence with the possibility of parole. And he went to several parole hearings. Now, luckily, the parole board in California had not lost their minds and they continued to deny his parole. So, excellent question. Excellent question, June. Now, your second question has to do with JonBenet Ramsey. And what is the latest on the JonBenet Ramsey case? And I didn't know, but that didn't stop me because I can't be stumped. And the reason for that is that I can always, hold on, a lot of buildup for this, Ritter. I can always phone a friend. So that's exactly what I did.
Hey, June, it's Paul with reporting live from my sofa. I do appreciate you calling in. I hope you are doing well. So I haven't followed the case a lot on my main channel, but behind the scenes, if I was getting paid per hour, how much of my life I have dedicated to just following this case, I would be retired at this point. Now, as far as major updates, there really aren't any, but I'm going to list off just a few. So, Mr. Ramsey, he did that interview with Crime Junkie. If you haven't checked that out, check it out. It's a few months old, though, at this point. Now, also in January, he met with the Boulder, I think the police chief, and talked about doing some kind of genealogy, DNA testing and whatnot. So there's that. Also, Cindy Mara, who's the daughter of the late investigator Lou Smith, she has taken up her father's work and she's done a spreadsheet, and there's a lot to be said there. So I would start doing those two things if you haven't done it and just see what you think of those. But, other groundbreaking things, sadly, there hasn't been. But anyways, I hope that helps, and I will see you around. Hey, June, it's Paul with reporting live from myself. I do appreciate.
I knew that was going to happen. Somehow there would be a problem. That was Paul from reporting live from my sofa. He's a good friend of the show, and we're a good friend of his, giving us the latest updates on the JonBenet Ramsey case. So big thank you to Paul. If you guys don't follow Paul already, please do. He does fantastic kind of deep dives in his own very special way with his own perspective, and I love it. And please give him a big thank you next time you're on his channel. If you guys do follow him, send him a shout out from Courtroom Confidential and tell him thank you for helping us out by being a phone a friend on Sunday Fun Day. Cannot be stumped. Can't be done. I have too many resources. All right. Thank you again, June. Let's move it along here. Hold on. Nobody panic.
Hi, Josh. My name is Lindsay. I live in Cincinnati, Ohio. And my question is, why do trials move a lot? We're getting ready to watch the Wagner trial, the fourth one, of the Pike County massacres, and they want to move the trial. Thank you for answering my question, and I'm a first-time caller and long-time watcher.
Thank you so much, Lindsay from Cincinnati, Ohio, for being a first-time caller and for calling in from Cincinnati, Ohio. So we're going to put you on the map. Excellent question. Pike County Massacre case, awful, awful, awful case. The latest Wagner family member is going to go on trial here soon, and they are asking to move that case. There's the 4 defendants. I believe it is Billy Wagner who's about to go to trial. Edward Jake Wagner already pled out. So did Angela and George. What is the latest on George? I think he's already had his trial. So just awful case about a complete annihilation of a family. There they are. Really sad. You're talking about 2, 4, 5, 6, 7. Yeah, 8 people. 8 people lost their lives. Almost the entire Roden family. Plus that was at Hannah Gilley. Just really, really sad. The judge on this case is pretty wild, doing some really mind-blowing decisions being made recently. But Lindsay asked the question on, there's a recent pitch to have this case, a change of venue, I think is what Lindsay is asking about. And I like this question because we do hear about this a lot. It seems like this is kind of the new popular thing to do, is ask for change of venue in these cases. Now, in a case like this, I think it might be appropriate. Piketon, my understanding, is a very small community, and this was such a huge case in that community that it might be difficult for them to not only find prospective jurors who won't be influenced by it, but you also have to think about, what do those jurors live in when they're not in jury duty? Are they surrounded by people talking about this case? Every single restaurant they go into, every single grocery store they go into, will it become known that they are on this case? Is it just so pervasive in that community that that community is not best situated to have this trial? That might actually apply in this case. But I do feel like you see these motions happening probably more often than they should. Change of venue, you have to write a motion, you have to give notice to the opposition, you have to have a hearing. It's like anything else. And basically what you're saying is that local publicity and local bias means that that venue is not appropriate for this case. And that's why I think it might work in this case. But when you see it in other cases, we saw it recently, there's a big push in the I'm blanking on her name, out of Utah, the mother. Help me out here, guys. They're trying to move her case. Oh, there's too many cases in my brain, and I start to. Corey Richens, right. Big push to have her case moved to a bigger area, bigger metropolis, bigger jury pool. The judge actually denied that. Now that's on appeal, and that's why the whole Corey Richens case has been pushed back. Here's my thoughts on these things. In a case like Piketon, such a small community might make sense. In a case with Brian Koberger in the Moscow community might make sense. But also, you would be surprised, and I've had this personal experience. I've worked on very high-profile cases. I've worked on cases that you would think there's no possible way that these jurors have not heard about this case, because it's the biggest case in the world, and it's so important, and it's all over the news. Some people just don't concern their lives with this kind of stuff, and I know that's shocking to all of us here today who do concern our lives with it, but there are some people that you ask them, hey, you ever heard about Harvey Weinstein? And they go, I don't know who you're talking about. And they go, well, this big, Hollywood mogul, and he's accused of, and he's part of the Me Too movement, and he's accused of all these kind of sexual misconducts. And yeah, I don't know. I follow the Dodgers. I care about my kids and the PTA meeting that I got coming up. I've got other things going on. I'm watching Devil's Kitchen. I'm watching, what's the one that I asked you about the other night, Tiffany, the $1 million listing. These are the things that people are concerned with. They're not always concerned with some big case. And you will find people who can therefore not be biased about it, or they've heard about it and they just don't really care and they don't have an opinion and they can not be biased. But maybe in a small community like this, it should work out. I don't know most of these cases. I don't watch the news anymore. So there you go. Debbie in Kentucky, you're going to get your jury summoned soon. All right, but great question from Lindsay. Let's keep it moving here, guys.
Hi, Josh. It's Aniki from South Africa. I would like to know the difference between your federal and state prosecutions. Should, say, the federal government find someone like the Alexander brothers or Luigi Mangione not guilty, if they're not guilty on a federal level, will the states take that into account, or are they totally separate processes? It sounds like the states are a bit more, not less lenient than the federal government. Thank you.
Aniki, our first international caller calling from South Africa. Let's put you on the map. Thank you so much. It's not surprising that this question is coming from an international caller, basically saying, what are you doing over there in the US? Why do you have all these different laws? And why can you have both the state and the feds prosecute somebody for the same crime? How does that all work? I'm confused and I'm a little worried. This is how it works. We operate under a federal system here, and I'm going to try to do this as simply and as quickly as possible so that we all don't lose our brains. We operate on a federal system here, which basically means each state is considered their own sovereignty, but they all operate under the sovereignty of the United States of America. And that's called the dual sovereignty system, federal and state. Each state has their own laws and judicial systems, and so does the feds have their own laws and judicial systems, and they operate many times concurrently. This is where both the laws and jurisdictions overlap. So you can have a murder in California, which violates the Penal Code section of California Law 187, and therefore is a crime in the state of California. It also violates a federal law for whatever they want to charge that person with. And we've seen that in cases like Alexander Brothers and Luigi Mangione. Now, why doesn't that invoke double jeopardy? Because the double jeopardy clause of the Constitution says essentially the way that it's been interpreted is that you cannot be tried twice. So here's the important things to keep in mind. One, tried twice. Thank you so much, Best Nancy, for the gifts. Tried twice. So gone on trial. That's an important part of double jeopardy. Two, for the same offense, meaning same elements. And three, by the same sovereignty, meaning same government prosecuting you. So you can see why in cases like Luigi Mangione, he can be prosecuted twice because he's being prosecuted for different offenses by different sovereignties. Okay. He's being prosecuted in the state of New York for murder, but in the federal court for murder with the use of a firearm. And they actually do have slightly different elements to them. So they're not exactly the same offense, and they're most certainly not the same sovereignty. And that's why you will see this happen, not all that often, but sometimes between state and federal cases. And where that becomes really mind-blowing is when somebody gets acquitted on the state level and then the feds say, knock, 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 don't go anywhere, stay in those handcuffs. We would like to put you on trial ourselves. And that's what's happening with Luigi Mangione. The state is going to go ahead and prosecute him first, and then the feds are sitting around waiting to do their job, where they are actually going to pursue the death penalty is from the last thing I've heard. So very good question, Iniki from South Africa. I can understand why you're confused, and I hope all of us are a little less confused, even though I am still thoroughly confused. Appreciate you. Let's keep it going here, guys.
Hi, Josh. It's Misconduct here from Hertfordshire in the UK. Thanks for having Sunday Fun Day on a Sunday evening for me here in the UK. My question is about the accused Gilgo Beach killer or Lisk killer. How strong do you think the case against him is? And do you think there will be some convictions that come out of it? Thanks. Bye.
Oh, thank you so much. Misconduct from Hertfordshire, UK. Put you on the map. Appreciate another international caller. Talking about Rex Hueremann, the Gilgo Beach killer, the Long Island serial killer, whatever you want to refer to this case as. And she asked the question, how strong is the case? First of all, what I will tell you is if you really want to know all the ins and outs of this case, we did a case notes episode. We will include a link in the notes, or perhaps we'll put it into the chat for you guys. And I think we're actually going to be working on an update of that because we did it a while back and there's been a lot of changes in this case. But how strong do I think the case is? Sneemac says she can't wait for this trial. I can't wait either. And then it's also therefore unfortunate that it's not going to be televised, but we will still be covering it very closely because it's, I think, a very important case and it's got a lot of moving parts that are very interesting. And here's some of those moving parts. First of all, there is DNA. There were female hairs found on several of the victims, along with male hairs. The female hairs have been matched back to the wife and daughter of Rex Hueremann through genetics and other mechanisms that I'll not go into all the details with here. The male hairs actually got tracked back to Rex himself. They were able to track him down, watch him discard a pizza box, pull DNA from the pizza inside of there, a crust. Always eat your crust, I guess, is the moral of the story. Able to match that to him. And then when they arrested him, they performed a buccal swab on the inside of his mouth and were able to match his DNA to a male hair located on at least one of the victims. Cell phone locations. They have his phone and then a suspect burner phone. The suspect was using a burner phone to contact many of these women to set up these meetings before he would kill them. They were able to trace the burner phone and Rex Hueremann's home, and they found out that, guess what? Every time this burner phone was active in contacting one of the victims, Rex Hueremann's phone was in the same exact location. And in fact, they never found, and this is what I like about the police work done here, they went back and said, well, was there ever a time where the burner phone was in a different location from Rex Hueremann's phone? And no, it was not. Then they went into a digital forensic search history of his computers and found out that he has a large cache of violent and torture pornography, really disturbing stuff that I don't even want to talk about here. They've described some of the things that he was searching for. And he had set up email accounts, fake accounts that can be linked back to him. And those accounts were used to set up and conduct a lot of these searches for sex workers and contact them and everything else. And finally, they did many search warrants on his home, and they found discarded hard drives. And on one of these hard drives, in the unallocated space, meaning if you have something on your computer and you delete that item, a document, and you delete it, that immediately is not erased from that computer until it is overwritten. But until it is overwritten, it sits in what's called the unallocated space. And the investigators were able to go back and pull this unallocated information. And they found a document entitled HK 2002-04. This document is nightmare fuel. It is considered a blueprint. It talks in the words of whoever created this document, which was likely Rex Hueremann. It talks about listing things as if what a person would need to do and remember to commit these types of murders. Topics such as problems, supplies, dump site, targets. He talks about preparation for the killings, post-event things to remember after the killings. The whole thing, again, I don't want to get into all the details right here on a Sunday morning, but the whole thing is beyond disturbing, and how specific he gets, things about how to wash the body, things about how to remove things like tattoos so they can't easily be identified. Really disturbing stuff that links Heuermann all back to these murders. So to answer your question, misconduct from the UK, I think it's a very strong case. And I think we've only heard just the tip of the iceberg about it. And I think it will be a fascinating trial to see how it all plays out. But they've done some. You remember the history of this case. It started out in the hands of a law enforcement agency who was just bungling it and dropping the ball and corrupt and crooked and everything else. And then when a new set of investigators came in, they have done real tremendous work, in my view, on this and really put together a very solid case, for all the reasons I just listed out. Thank you again from misconduct. Let's keep it moving here.
Hey, Josh, Johnny Knoxville in Chapel Hill, North Carolina, a.k.a. Christopher is my real name. So I had a vehicle stolen from me about 12 years ago, and the police asked me to come down to the police station for fingerprinting. And of course, this caught my attention because I'm thinking I didn't steal my own car. They wanted comparison prints. And it felt a little bit uneasy. I felt uneasy about that. Because if I give fingerprints, I'm assuming those fingerprints are going to then go into a database, even though I haven't committed any crimes. I understand why they want the prints, but shouldn't I feel uneasy about that? Should I consent to that? Is that something I should have done? And the second part of the question is it not a Fourth Amendment violation for the government to have DNA or our fingerprints in a database that we don't, even though we haven't committed a crime? And how long should they be able to keep those? So I guess you kind of get the gist of where I'm going here. Anyway, that's it. Thank you, and have a great sunny Southern California afternoon.
Johnny Knoxville, thank you so much, my friend. Good to hear from you. Calling from Chapel Hill, North Carolina. Put him on the map. Johnny, what have you got to hide, my friend? What are you so worried about? You got nothing. You got nothing to worry about if you got nothing to worry about. Great question, though. What is the government doing with all this stuff, and why should I just be handing it over to them? Well, first of all, as far as your fingerprints go, you're absolutely right. All they're trying to do is create a example, something to work off of, so that they can exclude your prints when they pull prints from your car. And by the way, congratulations that the police even care enough to actually pull prints from your car and do something about trying to investigate a car theft. Many places where I live, they would just say, good luck with all of that. Let your insurance company know. But that sample, that fingerprint that they pulled from you is not going to be entered into some database, mainly because of funds and mainly because these databases do actually have protocols on what can be entered, and just somebody providing their fingerprint so that it can be used as to exclude other prints. Likely not going to happen. Should you consent? I think you should. And again, unless you got a reason not to, and if you do, feel free to give me a call and we can chat about that on an attorney-client privilege phone call. But you can always tell them, I'm giving this to you, but I'm not giving you consent to enter this into some sort of database. And then they might look at you sideways and wonder why. But I don't think that they're going to do that. But your bigger question is, what is happening here? Is it a Fourth Amendment violation to have this DNA, more DNA, I think, than fingerprints in a database? Well, one, many of what's in the database, let's limit it to DNA. Much of what's in there has been put in there either voluntarily, meaning you had to do a background check to get some sort of government job, or you've had it done involuntarily, but you not abusive of your constitutional rights because you've been convicted of a felony, you've gone to prison, and they're going to swab you to put you as part of the database. But what about other things like DNA picked up from different crime scenes and those being entered into a database? Isn't that abusive of my Fourth Amendment rights? The answer is no. because that is considered at that point an abandoned item. So you put a fingerprint at a crime scene, the law considers that as that you've abandoned that. You leave your DNA on a object at a crime scene, that's considered to be an abandoned property, an abandoned item. You leave your footprint in the mud outside of the home that broke into, that's considered to be an abandoned item and does not invoke any privacy concerns with the Fourth Amendment. Basically, it all comes down to reasonable expectations of privacy. Do you have a reasonable expectation of privacy in these things? And you do not have a reasonable expectation of privacy in committing a crime. So you break in somewhere and you happen to drop your cell phone, you do not have a reasonable expectation in that phone any longer, or leaving around a knife sheath, or leaving footprints, or leaving DNA. All of that stuff is all fair game for the government. And what they'll do is they will then enter that into a system and check it, usually CODIS, across all of these other Fourth Amendment, in other words, not a problem with the Fourth Amendment database of suspects to try to figure out who the heck it was that left that knife sheath at a crime scene. Not to get into a whole side journey here, but that's why the whole IGG and the federal government using ancestry websites and everything else became an issue, is that did that abuse the Fourth Amendment rights of those people? And what it came down to and what the judge finally decided is it didn't, because they don't have standing and the government only broke their own internal protocols and not any kind of law. So anyhow, not to get into that whole side quest. The long and the short of it is, one other thing though, I wrote a little note for myself about this is, what about your DNA if you submit your DNA for exclusion at a crime scene? Does the government then enter that into a system or hold on to that? And the answer is that no, but how much can we trust that, first of all? Because they can't just be entering a bunch of things into CODIS, but do they save that DNA? Do they preserve it? Do they dispose of it later? That's maybe a bigger question. And then the other question becomes, what about corporations? And again, this is not the government, so it doesn't invoke the Fourth Amendment, because that's what the Constitution deals with. It deals with the government, not with corporations. But we talked about this in law school. What if you're sitting for a job interview and you happen to touch an item on the desk of the interviewee, and when you leave, they pick up that item and they run your DNA because they want to see a whole bunch of things that they weren't allowed to ask you questions about. Perhaps your health history, and they want to know whether or not they're going to hire this prospective person based upon DNA on a disposed item that you left during that job interview. I know I'm gone really on a sidetrack here by this question, and Afton asked, does it vary by state? No, because we all follow the same Fourth Amendment, but it may vary by state as far as how quickly they're able to test some of this stuff, and so how much of it they might collect. Finally, you made me think of a story. I'm very sorry that you had your car stolen, Johnny, and I hope that all works out fine for you. I hope they catch the guy. But I got a funny story for you. When I was a much younger man, I don't even think I was in college yet. I think I was out of high school and maybe starting to go to college. I had an absolutely awesome 1970 Chevy Nova. Loved this car. And I was doing some work on it and trying to fix it up. And it was just this was my favorite car I've ever owned. I brought it to a mechanic, was having some work done on the brakes over the weekend. I go to pick it up on Monday, and my mechanic is in a full-fledged panic when I say, where's my car? Because he said, I thought you already got it because my car's not there. And we're searching all over for my vehicle. And it's funny how when something like this happens to you, you don't realize quite yet that it's happening until it's, I kept on waiting for him to go, oh, here it is. And then all of a sudden we're calling police and being like, yeah, somebody stole my car. I was devastated, mainly because I didn't even have the money to buy another car. So I don't know what I'm doing. I'm literally searching, I think, Craigslist or the whatever online car thing to try to find the cheapest car I could, just so I could get to and from work and college. Maybe 2-3 weeks later, I get a phone call late at night. I'm still living with my parents. It's like 9 p.m. at night. I answer the phone. This was when phones were actually on walls and had a ringer and ring, not my cell phone. It's our house phone. I pick it up and they say, "This is Santa Monica Police Department. We'd like to speak to Joshua Ritter." And I go, "Oh boy, what did I do?" And I go, "Speaking." And they say, "Did you own a green 1970 Chevy Nova?" And I go, "Yes, I did." And they go, "Well, it's no longer green, but we have it." And I go pick up this vehicle and it has a brand new, beautiful paint job done to it. Now it's kind of a shiny midnight blue. I had been working on the dashboard. It was all kind of like falling out. The dashboard had been all fixed up and it had a brand new stereo system in it with a brand new Red Hot Chili Peppers CD inside the stereo. And they said, "Here's the keys. This is your vehicle." And I was absolutely blown away because I thought they were going to tell me it's been stripped and it's sitting on cinder blocks and, here's your car. Good luck with all of that. It was in much better condition and had a bunch of work done to it that I couldn't afford to do myself. And about a week after that, I got a call from the same police detective. And he says, "So we did arrest the guy. We are, charging him." He asked the question, though, "Was there a new speaker system put into your vehicle?" And I said, "Yeah, there was." And he goes, "Well, the guy is asking if he can have that back because he put those speakers in there." And I said to the police officer, "Well, do I have to?" And his words to me were, "No, you can tell him to go F himself," stronger than that. And I said, "Well, why don't we go ahead and do that?" And so the end of that story was I got myself a new speaker system, and I figure you steal my car, that's the least you could do. So that is my story about having your car stolen, and I doubt that they all work out that way. But great question. Thank you, Johnny, for asking. All right, let's keep it moving.
Hi, Josh. This is Gloria from Florida. I just have to make a record, as you lawyers say, that I wasn't speaking of you when I mentioned YouTubers getting sued over things that they say on their chats. I was actually speaking of Gisela K because she's snarky, and I'm there for the snark. But she was snarking it up about Stephan Sterns' jail calls with his parents. And having a good laugh. So that's kind of why I brought that up. That was all. But you answered the question when you said that it's mostly opinion. So that explained it. All right. Thank you, Josh. Bye.
Thank you, Gloria from Florida. You're so cute. That's so funny. I was not offended if you thought that I was at all. And we're going to put you on the map for asking the question. And I appreciate you for clearing things up. Gotta love Gisela. Gotta love the snark. And no, she's not getting sued, and neither away, so she can snark all she wants. And I hope that she continues to. There she is. What is it? Oh my word. She is, no one's ever coming after her. And if they do, Gisela can call me. So thank you so much, Gloria, for clearing that up. I appreciate you. All right, let's keep it moving along here.
Good morning, Josh. My name is Jan. I live in Springfield, Illinois, and I agree with you about the weather in Illinois. We have approximately 3 good months out of 12. My question is regarding defense attorneys. How are they chosen, And gosh, what if they feel like the defendant is guilty? Is there anything they can do? Do they go to the judge and say, look, I think he did it? And also, I'm kind of curious about what happens if this person is set free and they do murder again. I can't imagine a defense attorney and how they feel if they feel that this person is guilty and they're let out. And I'm going to refer to a case in Florida in Polk County, Collin Griffith. He murdered his dad in self-defense, or he killed him. And then he went to live with his mother about a year later, and he killed her in self-defense.
Thank you so much, Jan from Springfield, Illinois. Appreciate you calling. Interesting question. I get this a lot. First of all, she asked, how are defense attorneys chosen? So really depends on what type of defense attorney you're talking about. If you're talking about a private attorney, I'm in private practice. Somebody hires me. They have to walk into my office. We have a meeting. They decide to hire me, and I decide whether or not to take their case. So there's a lot of decision. You know, I will turn away cases. You know, I don't feel like we're a right fit. I don't want to handle that particular type of case. And maybe it's too big for me or too small for me, whatever it is. Many times attorneys are referring out cases to other attorneys. And then there's public defenders who are working for the government. They are being paid by the county. They are taking whatever case is handed to them, because that's the purpose of them, is to handle these cases that where a person cannot afford an attorney for themselves. So they cannot say no. In fact, in only the rarest of circumstances can their client, the defendant, even fire them, and they get a different public defender. So they're kind of both stuck with each other, as it were. But then to your second question is, what do you do if you're an attorney? And I imagine, well, I guess it would work for either. And you feel like your client's guilty. What do you do in that situation? Your first question, Jan, is, do you go to the judge? The answer is absolutely no. Can you turn the case down if you're a private attorney and you don't want to represent someone because you just don't want to represent that person in that type of a case? Absolutely, you can turn it down. But many times you're not. I mean, people, listen, you know, this is kind of the way it works. Most people who are looking for a criminal defense attorney and been charged with a crime may have done something. They're all presumed innocent, but they're also, the government just doesn't go out and arrest random people. So those people might be in a little bit of trouble, and that's your job, is to protect them and help them and hopefully get them out from underneath this trouble. But I think, Jan, your question is kind of more about what if some sort of ethical, moral crisis takes place in the middle of your representation of someone. Now, there are some opportunities for a defense attorney to fire their client. They can say, I don't want to represent this person anymore. Our relationship has broken down. This person has lied to me. I can't trust them, whatever it is. But sometimes you get locked in. And there are instances where an attorney says, I want off the case, and the judge says, too late, you're on the case. Attorney says, I haven't been paid. Judge said, not my problem. We're not delaying this case just because here late into it or too far into it, you've decided that you want another lawyer. That is also rare. There are usually opportunities for attorneys to get off a case if they don't want to represent that person anymore. Sarah Boone. Yeah. Great sarcasm. Great reference there. Yeah. She went through plenty of attorneys who said, no Moss. I don't want to deal with this person. I can't get along with her. So they replaced her. But I imagine if her last attorney had started trial and said, I don't want to do this anymore, the judge would have said, too late. And then the question of, what do you do if you represent someone and you get them off and they go out and do a horrible thing again? And she brings up the case of Collin Griffith, which is a horrible, nightmarish case about a young man who had gone to trial in Florida for murdering his mother. He had said that he did it in self-defense. The jury agreed with him, found him not guilty. But the jury was aware that he had been involved in a shooting before where someone had died and he had claimed self-defense. They were not aware that that person happened to have been his father. So now he's killed both his father and his mother and claims self-defense in both. The interesting thing about this, though, is he was never charged for his father's death. They investigated it, felt that they couldn't prove it, felt that they couldn't bring charges. So double jeopardy has not attached. Oklahoma could still charge him for his father's death. That will be interesting. And last I heard, Oklahoma is taking a real strong look at that case again, and they may very well open up that case against him. There's no statute of limitations on murder. And so they may go back and charge him for that case. Anyhow, I think it would have been more interesting to our discussion had he been acquitted of his mother's death and then went out and murdered his father, as far as like, what kind of mental turmoil are the attorneys going through. But, it is not an easy job, and it is a job that many times you have to compartmentalize your life being a defense attorney. But great question, Jan from Springfield. All right, let's keep it moving along here. So many great questions today. You guys are fantastic. Again, happy Mother's Day. Thank you for showing up, and thank you for always bringing the hot heat with these questions.
Hi, Josh, Tiff, K, and mods and the CC crew. It's Joy W from Ottawa, Ontario, Canada, calling again. You've already got me on the map. I'm going to try and ask a question without rambling and mixing up metaphors and sounding stupid. Anyway, so my question is, what is the difference between a proffer, a deposition, and a voir dire? And when would you use those? I just want to prepare us all for JC Broadway's next quiz, and I want to get my CLEs in. Anyway, thanks. Bye.
Thank you, Joy from Ottawa, Ontario, Canada. We're putting you on the map. Everybody goes on the map. So thank you so much for calling in. Yeah, we throw around these terms, proffer, deposition, voir dire, a lot. And I sometimes take for granted that you guys might already know what they mean, but maybe you don't. So here is your quick little bit of law school. A proffer is a interview done with law enforcement where you have immunity during that interview. In other words, what it's sometimes referred to as a queen for a day. The federal government loves to do these. State governments, for some reason, are less inclined, and I don't understand why, because they're an excellent investigatory tool. But basically what will happen is somebody will be under investigation by the feds, and the feds will say, they will come to you and say, well, listen, does your client want to cooperate? Because usually federal investigations are involving many, many different defendants, and they're all trying to get towards the one big fish in the middle. So they come to your client and they say, does your client want to cooperate? And you say, yeah, my client wants to proffer. So they will sign an immunity agreement, and it says that everything that you tell us, we cannot use against you. But we can take what you tell us and use it to investigate other people and develop our further investigation. And if our investigation reveals your involvement in a way independent of what you tell us, we can still use that, but we cannot use anything that you're about to tell us against you if we still decide to proceed on a case against you. And you say to yourself, well, why would somebody do that? Well, they want to do that because they want to impress the government so that the government makes them a witness rather than a defendant. The government says, you are telling us such valuable information and you are so helpful and you're helping us out so tremendously that we don't want to make you a defendant. We want to use you as a cooperator, and perhaps you stay as a defendant, but we're going to give you a fantastic deal as a cooperator. And thank you so much for this proffer. The one little caveat on a proffer is if you don't tell the truth and the whole truth, they throw out the whole thing and they rip up the proffer and they say, we're coming after you because you're useless to us now because we can't trust you to tell us the truth. That's a proffer. A deposition. A deposition is sworn testimony, but it's done outside of court and outside of a jury. It's where you're under oath. There's a court reporter. There's both sides of the case. Many times this is a much more civil thing than a criminal thing, except they do it in criminal cases in Florida, which is kind of wild to me. But usually the way I've seen it is in civil cases where you're trying to gather information. And so you want to interview a bunch of witnesses. You want to get their testimony under oath in case you need to use that at a later time. And so therefore both sides sit down. There's a court reporter writing down everything. You ask your witness a bunch of questions and they're cross-examined and it's full-fledged testimony. And in case that person is not available, or in case you just don't even want to use that person at trial, you can't substitute by using their deposition testimony because it's seen as just as good as trial testimony. And then finally, voir dire. Voir dire is just because lawyers like to be fancy and use fancy terms, basically means to speak the truth. It just means to question someone. It's questioning usually of jurors during jury selection. It's just another way for saying jury selection. So you bring in a bunch of jurors during the voir dire process and ask them a bunch of questions about who they are. And jurors, by the way, are put under oath. Before they answer a bunch of questions during jury selection, the entire veneer, the entire panel of prospective jurors stand up and take an oath to tell the truth because we want to know exactly who they are, what biases they may have. And that's what voir dire is. One other place you will see the term voir dire used is sometimes a attorney will want to question a witness. In other words, take them up on cross-examination out of order. And that is usually because you're challenging the foundational issues of this witness. And that can sometimes be done in front of, but most times it's done outside of the presence of the jury. So you may say, this witness who's about to testify, I want to take them on voir dire and question them whether or not they foundationally can meet certain standards to even testify to the things that they're going to testify to. You see that sometimes done with experts. You see that sometimes done with lay persons who are going to testify to something in kind of like an expert capacity. And you want to make sure, hey, I don't even think this person's qualified to answer these questions. I want to cross-examine them on voir dire to see if they can, and then we can proceed with whatever kind of objections. And I hope that makes sense to everybody, and I hope it wasn't too long-winded, but I appreciate you, Joy, for asking another excellent question. Ed, yes, Captain Rhett Snuggler says, if you haven't already, please hit the like button, and I hope that you do that. Do it for your moms. Do it for your kids, for your doggies, cats, and horses. Please hit that like button. All right, let's keep it going here.
Happy Sunday fun day, Joshua, crew, mods, and chat. And guests, this is Alicia K. Mayo from Humboldt, Tennessee. Back on April 16th, 1987. So it has been a good while. Little 4-year-old Marlena Childress disappeared from her, I believe it was her family's front yard in Union City, Tennessee. And since then, there has been different stories from her mother. I do believe a couple other people. And she has never been located. Joshua, has there been any recent updates in her case? And if not, what, if anything, could possibly be done to find this poor child? Hope you all have a fabulous Sunday fun day. Thanks. Bye.
Alicia K. Mayo, love you so much. Love hearing from you. Humboldt, Tennessee, put it on the map. Another case I never heard of. Really fascinating, horrible case from 1987, as Alicia K. brings out. So here's what took place. In 1987 in Union City, Tennessee, this case gets a little wild, so buckle up for this one. Marlena Childress is a young girl. There she is, beautiful young girl. Disappears from her front lawn. A witness apparently hears the sound of squealing tires. She's never seen from again. Her mother, Pamela Childress, suffers some sort of mental breakdown and actually checks herself into a hospital with exhaustion after the disappearance of her child. After she gets out of the hospital, she does an interview with police where she allegedly confesses to accidentally killing Marlena, and dumping her body in a nearby river. The police search that river. No body is ever recovered from there. Later on, Pamela recants and says that I was under the exhaustion of the moment. I was coerced by threats from the police detective, that the detective told me if I didn't tell them what had happened, I would go to the electric chair and he would make sure of that. And that if I just say it was an accident, that probably I'll receive some mercy. And so that's why I did what I did. And she recants the whole thing. And the judge, and this is the part I was unclear about, the judge or law enforcement actually rejects the case against her. And she is never criminally prosecuted. So it's not like she went to trial and won. She's never actually brought up on charges for this. So now this case goes into a cold case, and she remains their lead suspect, but they pursue other suspects. Then it becomes one of those cases where they feel like there were sightings of Marlena, and there were reported sightings, across the country, people feeling like they had found her. The latest was actually in 1990 out of Nevada. If this wasn't wild enough, here's where it turns even more wild. In 2002, Pamela has moved now to Kentucky. She's got a 12-year-old son, and she tells him, I have a surprise for you. She drives him to a cemetery, blindfolds him, brings him to a gravesite that apparently had the word son on it, and stabs him. He survives this stabbing, but she is caught, convicted, and does 10 years for attempted murder in that case. She has still never been charged with Marlena's murder or disappearance. So, to answer your question, Alicia K., I don't have any further updates. I don't know what can be done for Marlena. But if you're asking me, the same person who would admit to this crime, then recant, then try to kill her son, probably is the person responsible for this young girl's disappearance. So a wild, wild case. Thank you so much, Alicia K. Mayo, for always bringing the craziness to us. Case I had not heard of, but as I was reading it, I was like, I cannot believe this kind of stuff actually happens. All right, let us keep it moving along here.
Hello, Courtroom Confidential. Happy Sunday. I'm so sorry, you guys. You're all going to be mad at me. I know, because she didn't get any votes. But what are Lori Vallow's chances of getting a new trial? Sorry, everybody. Okay. Thank you. Bye.
Sonia, you have nothing and never will have anything to apologize for. Great question, Colin from Chicago, Illinois. Asking about Lori Vallow. Ain't no shame in that. She's asking for a new trial. There's this whole kerfuffle with juror number 15 and all of that nonsense. The prosecution has now responded to that. What are her chances of getting a new trial? Well, I really think it comes down to what, if any, evidence was there of this juror actually. First of all, Lori makes a lot of arguments. She says things like prosecutorial misconduct and, a bunch of other kind of nonsense. None of that's going anywhere. The only thing that's got any kind of teeth to it is this juror number 15, this gentleman right here, and the comments that he made about alluding to that he may have become aware of her prior convictions during the time that he was deliberating. If Lori is able to prove that either by bringing this juror in and having him admit to that, or providing some sort of other evidence that this was in fact true and not he misspoke, misinterpretation of what he was saying, and that played a role in either his decision-making or that he told the other jurors about it, then we've got some serious problems. But if he didn't tell any other jurors about it, or he did misspeak, or he did know about it, but it didn't affect his decision-making, and he can say that, probably not going anywhere. And I know that sounds wild, but listen, we live in a world where people are going to inadvertently find out about something. And as long as they don't share that information with the other jurors, and as long as they don't allow that information to play a role in their decision-making, then we can't just have a mistrial and new trial on every single time that this inadvertently happens. I guess that's the other thing to point out. If he did this on purpose and looked into it, that could be a problem too. So the answer to your question, Sonia, is we're going to have to find out what exactly this guy knew, how he found that out, and who he shared that with, and what he did with that information before we can have a more clear understanding as to see where this is actually growing. Great question, Sonia from Chicago. Appreciate you. All right, let's keep it going.
Hi, Courtroom Confidential God and Goddesses. This is Maureen from Monterey, and I have 2 questions. I may have to record the second question in the next recording, but the other day I was listening to Andrea Burkhart doing a recap of the Karen Reed trial, and she brought up what I thought was a very interesting point. She explained that the prosecutor obtained an indictment by going before the grand jury with a specific theory of the case, and that since then they have altered that theory somewhat. Now, I'm at a little bit of a disadvantage because I did not watch the first trial, so I'm not exactly sure what she means. But she feels that if you get an indictment based on one thing, and then as you go along, you change that theory, you should have to go back to the grand jury and get a new indictment and not just sort of coast along based on the indictment that you got. I think that's a very valid point. And I was really wondering what you thought about that. I'm going to run out of time, so I'm going to record the second point. This is Maureen from Monterey with Andrea Burkhart's second point, which involves double jeopardy. She believes that if you take a case to trial and you go all the way through the prosecution and defense and the rebuttals and the closing arguments, and you give the case to the jury for deliberation, and they come up with a hung jury, she feels that you should not be able to get a new trial based on that, that should be a violation of double jeopardy. Because you have done your best, you've presented your case, and oh, too bad you didn't get the result you were looking for if you're the prosecution. I agree with her. I think that's a valid point. It's one thing if you have to declare a mistrial because you find out there is witness tampering or some jury irregularities or something to that effect. So you have to stop the trial mid-trial. But it's another thing to take it all the way to the end and not get the result you want. I agree with her as I think about it. And I was wondering, Josh, how you feel about this. Thanks again for these Sunday Fun Days.
Thank you again, Maureen from Monterey, California. Let's put you on the map. Appreciate you calling. Excellent questions. Andrea Burkhart, very, very smart, very bright, very, I'm a big fan of hers. And in fact, If you guys are a fan of hers, check out the conversation that we had with her. That was one of our early conversations. We had a really nice chat. She's a very, like I said, brilliant, bright lady who does a lot of research. With that all being said, I totally disagree. With the utmost respect to Andrea and to Maureen. Let's go to the first question about if the government alters their theory during their indictment, should they have to go back and get another indictment? Well, the answer is one, no, they don't have to. And we'll talk a little bit about, can they do that? Yes, they absolutely can change their theory, because cases are not based upon theories. They're based upon facts and whether those facts satisfy the elements of a crime. And theories may help jurors understand how the facts satisfy the elements of a crime, but the theories themselves are not something that need to be proven. So the burden of proof is on the government to prove the facts that satisfy the elements. And if they happen to use different theories to get there, so be it. The theories are not what this case is being decided upon. And the same thing goes for indictments. And in fact, this may blow your mind a little bit, but the jurors themselves don't need to agree upon the theory. The jurors can have different theories to satisfy the same elements of a crime. Okay, here's how that might work. Two different theories for first-degree murder are felony murder and premeditated murder. Premeditated murder is malice aforethought. I meant to kill this person and I killed this person. Felony murder is I didn't necessarily mean to kill this person. I meant to rob this person with a loaded firearm. And in happening to rob that person with a loaded firearm, I killed that person. And the law says, well, you commit a felony, certain felonies, and somebody dies during the commission of that felony. The felony murder rule theory says that that is first-degree murder. So those are two different avenues to arrive at first-degree murder. The question before the jury is this person guilty of first-degree murder? Not, is this person guilty of first-degree murder by these different mechanisms? And both of those theories might be presented to the jury. And the jurors may go back there and go, well, I believe when this guy robbed the liquor store at gunpoint, he actually did mean to kill that clerk, because I had heard evidence that he didn't like him anyway. So I think he went in there, meant to kill him, and the robbery was part of that. Or you could be one of the jurors that says, no, I don't think he really meant to kill him, but he went in there and he was committing a robbery and he had a loaded firearm and he was, had bad intentions to begin with, and he committed the felony of robbery, armed robbery, and somebody died. So I'm going to say it's first-degree murder by way of the felony murder rule. And those people don't have to agree on that. Those are different theories to arrive at the same crime. So that's why the government is not required to go back when they switch theories and get themselves a new indictment. And not guilty voters have the same freedom. They don't They don't have to agree on why they're voting that way. That's also true. You don't have to find not guilty based upon the same theories. You could have different problems with the case. One person could feel like intent was satisfied, but identity wasn't, or whatever it is. You're right. They don't. Great point, Afton. So we put a lot of burden on the government, and we put a lot of questions before the jurors, but agreeing upon theories is not one of them. But I understand, and I totally respect Andrea's position and Maureen's position that, maybe they should. The other question is, should a hung jury invoke double jeopardy? And this one, well, let me ask you this. Are you willing to make juries not unanimous? In other words, maybe we can have a discussion about that if the prosecution only has to get 10 out of 12 or 8 out of 12. That's good enough for a guilty. Sure. If you want to start playing that game, but if you're telling me that they hang a jury 11-1 for guilt, and that person walks because of double jeopardy, that is not a world I think that is realistic. I mean, listen, the prosecution has, first of all, the burden of proof. People are proven innocent or presumed to be innocent. Then they have the highest standard of proof of proving that it's beyond a reasonable doubt. And then they have to convince all 12 people unanimously. And I realize that some jurisdictions don't operate the same way. They don't have the same number of jurors, and they don't have unanimity. But if all of that is not satisfied, and you've got one holdout juror, two holdout jurors, or even more than that, 6 holdout jurors, then I do think what we're talking about is that you did not complete a trial. We did not arrive at a verdict, and we're going to declare a mistrial. And then the idea of double jeopardy is not invoked, because remember when we were talking about double jeopardy earlier, the first prong was you have to be tried. And if you have a mistrial, you're not considered tried. So they can go after you again for another trial. And I guess too, that in my experience, I've just seen far too many cases. I've been a part of far too many cases that have deadlocked, had hung juries, and then gone back and had convictions, and rightfully so. I mean, Bill Spector, his first trial hung. I'm trying to think of other cases where they've had hung juries and had to go back and do it again. Anyhow, great questions. I get it. I just feel that, we've already, I felt, done quite a bit to tilt things in favor of making sure that everything ends up fair. And if we start saying that all the defense would have to do then in that situation is convince one person, that seems like a hell of a game. Hell of a tilting in favor. Chris says, I think Andrea was referring to the 2 charges they found not guilty on, but could not agree with the 3rd charge, which is why they hung, and the jury was not questioned about the charges. Excellent question, Chris. In that instance, we're not talking about double jeopardy and hung juries. What we're talking about, that jury did not understand their job correctly. And if you want to get into, do we need to reword jury instructions or the verdict slips or whatever you want to call it, we can have that discussion all day long, because I am just as bothered and offended by the idea that jury is apparently back there saying they acquitted her of murder and then just didn't let anybody know. That's, I think, a major problem. But I think, to me, a separate problem from whether or not had they come back and said, we're not guilty on the first charge, she would not be on trial for it. I mean, that's how it works. But they didn't say that, and that's where the problem is. They came back and they said we're hung, and I cannot think of another case where it was so clearly a problem as it was in this case. Just a wild set of circumstances that is kind of a different question from the double jeopardy question. But excellent point, Chris. Excellent question, Maureen. Keep them coming. All big love to Andrea Burkhart, but I don't agree with her on these ones entirely, though I think she's smarter than me, and I don't want to debate her on it because I probably end up looking really silly. All right, let's keep it moving.
Hi, Josh. I'm Georgia from OKC, Oklahoma City, and I just have a little question to ask you. I see you on so many other shows, and I see other people on your show. Now, when you appear on someone else's show, do they pay you or do you pay your guests? I was just curious because you guys spend so much time going from one place to another. Plus, I know you work full time. I was just curious. I mean, you guys keep so busy. I absolutely love watching your podcast and learning from you and your guests. But I just wanted to say hello. This is my first time, so I'm kind of a little nervous. But hi to everyone from Oklahoma. And I hope you read this so that, or hear it so that you can answer my question. Thanks a lot. Bye.
Georgia from Oklahoma City, Oklahoma. Thank you so much. That's so sweet of you. I appreciate all those kind words. Let's put you on the map. And thank you for being a first-time caller. Appreciate that. Who is getting paid? I have made the whopping figure of $0 from appearing on other people's podcasts, and I've paid out $0 to anybody who appears on our podcast. It's all just about love, and it's all just about helping each other out, and I'm more than happy to do it, and more than happy to help support other YouTubers and creators and podcasters, and I appreciate when they do it for me in return. Like for instance, today with Paul, that was just a phone call and said, "Hey buddy, do you mind?" And he was kind enough to do it. So I appreciate you asking. I appreciate you giving the kind words and encouragement. We are working at this very hard. That's why we always appreciate all of the kindness and generosity that you guys extend to us in whatever small way that you can. But yeah, this is all about love and kind of getting the word out there. Tiffany, I was talking to Tiffany about this, and she said in the publicity world, they would call this earned media, meaning that it's just simply for networking and promotion and letting other people know that your channel exists, and us letting all of you know that other people's channels existed, and exposing each other to all sorts of diverse voices. So thank you so much, Georgia, for bringing that up and for the kind words and encouragement. It put a smile on my face. And thank you for being a first-time caller. Hazel says, I love creators who support one another. I do too. I think all ships rise with the tide, and I'm happy to promote as many people as I possibly can. And that's part of the reason we're doing that conversation series, is just, hey, have you guys heard of these folks? All right, let's keep it moving.
Hi, Josh. This is Gloria in Central Florida. I was just wondering, when I'm hearing Alan Jackson cross-examining Buchanan in the Karen Reed trial, it's obvious that Buchanan has rehearsed with Brennan all that information when they were viewing the video in that first bar, and they were counting the drinks that she was having, and they were counting the shots she was putting in her drinks. They obviously rehearsed that, and the information was all there that they could use, obviously. Not so good for Karen. But I noticed that Alan Jackson doesn't say, how many interviews did you have with Brennan? How many times did you get together and discuss this testimony today? As he did with the civilian witnesses like Jen McCabe. And I just wondered, is that because Buchanan is a police officer and law enforcement is assumed to be working together with Brennan? And so it's not an issue to bring up, oh, how many hours did you two go over this testimony? I was just wondering, because it seemed like that was a big gotcha moment when Alan was trying to say that Jen McCabe, worked together with Brennan. Okay, I was just wondering. Thanks, Josh. Bye-bye.
Thank you so much, Gloria from Central Florida. First of all, you're going on the map. Appreciate you calling in. Great question. Again, we're talking about the Karen Reed case, Alan Jackson, Hank Brennan, Sergeant Yuri Buchanan, and whether or not Buchanan was it rehearsed? And I would say, I don't think rehearsed as much as I would say prepared. And they probably did have several conversations. I will tell you a story. My very first trial as a prosecutor, I was nervous. I was making mistakes and learning along the way. And it was a misdemeanor case about one guy had attacked another guy in the bathroom at a bar, and he had swung at him with a beer bottle. And so it was actually charged as an assault with a deadly weapon, because almost anything can be a deadly weapon depending on how you used it, but it was a misdemeanor. And I did not speak to my victim ahead of time because I was nervous, and I was thinking, I don't want to I don't know if that's right. I don't want to influence him. I don't want it to appear as though I'm trying to prepare him or rehearse with him. So I just put him on the stand cold and went off of the police report. And we're at the most dramatic point in the trial. And I'm asking him, so now when the defendant who's sitting here in court approached you with the beer bottle in his hand, tell these jurors what he did. I'm not even joking. He said, he goes, "Get out of here." Like he's holding the bottle. "Get out of here." And I look over at 12 jurors who are looking back at me going, I missed my kids' soccer practice for this nonsense. You're telling me that you had me sitting here paying parking, walking to the courthouse to sit through this absolute hot garbage. And I could just feel if I could have shrunk within my suit at that moment, but it taught me a very incredibly valuable lesson that, boy, you better talk to your witnesses ahead of time. And for every witness since then, you believe I talked to them ahead of time. Now, there's a difference between talking with and interviewing and preparing even a witness and rehearsing. I would never tell them, when I ask you this, you say this. I'm going to ask you this question. I want you to tell the jurors X, Y, and Z. But I'm certainly going to ask them, when the guy came at you with a beer bottle, what exactly did he do and say? I'll never forget that. Quickest, by the way, fun fact, quickest not guilty I ever had in my career as a prosecutor. They went back to the jury room, and before I was packing up my bag, they buzzed the buzzer, meaning that they had a question. And their question comes out, and it was a Friday, and they said, if we don't have a verdict today, do we have to come back on Monday? And the judge sent them back the answer of, yes, you do have to come back on Monday. And then before they even had time to read that question, we heard two buzzes, meaning they had a verdict, and they came back out on a Friday afternoon and said not guilty. And I don't even think I had packed up my bag before that not guilty. So lesson learned. And the rest of my career only went up from there. So if you're going to start low. Anyhow, is Buchanan rehearsed? I don't think he's rehearsed. I think he's prepared. And so your question was, why isn't AJ asking him the same questions of how many times have you spoken to the prosecutor? And that's true, because he's on the prosecution team. This isn't a civilian witness who's supposed to be objective and no real dog in the fight and only telling about what they saw and heard. This is an investigator. He's involved in the case. So of course, if Alan had asked them that question, he'd say, I speak to him on a daily basis. I've spoken to him dozens, if not hundreds of times about this case. I'm one of the investigators. I'm intimately involved. That's part of my job and part of his job to talk about this case. We've talked about it many, many, many times. Doesn't work that same way with a civilian witness, because then it starts to look nefarious. Now, again, there's nothing wrong with the prosecution talking to these civilian witnesses. In fact, they do and should. But in the hands of a skilled practitioner like Alan Jackson, it can start to take on this very ominous inflection and perception by the jurors that, oh, wait a minute, you're talking with the prosecution? Well, what are you talking to them about? What do you need to be talking about them about? And in actuality, yeah, prosecutors talk to their witnesses. We want to know, what are you going to say? I see that you said this in the police report, but what did you actually see and hear and do and tell the police officers that day? Another lesson I learned as a prosecutor is, because defense attorneys love to ask that question, and they'll do this after a break too. I will do this as a defense attorney now. A witness will be on the stand. We'll have a break. They will go back, and you'll see that the prosecutors may be talking to them in the hallway. And you love to ask, what did you talk to them about over the lunch break? Did you talk to the prosecution over the lunch break? What did you talk about? And everybody gets nervous, and it's like, did I do something wrong? And I would always tell witnesses, when I would talk to them over the lunch break, I would say, I'm going to ask you X, Y, and Z. You're doing great. Here's some stuff I want to kind of clarify in my examination. Now, when you get back on the stand, you may be asked by the defense on cross-examination, what did we talk about? Or did we talk about? Yes, we did. There's nothing wrong with that. And if they ask you, what did we talk about? Or what did I tell you? I want you to tell them, and this is absolutely what I'm telling you, that I want you to do nothing but testify to the truth. And boy, would I love it when the defense attorneys would ask that question then after lunch. Did you talk to the prosecutor? Yes, I did. Oh, you did. And what did he tell you? He told me, above anything else, please make sure that I testify to the truth. And the defense attorney would shuffle his papers and, okay, well, moving on to another thing. It was a great moment. I enjoyed that kind of stuff. Anyhow, great question. Gloria from Central Florida. Let's keep it going. A few more questions here, guys.
Hi, Josh, Tiffany, Key, and the whole CC family. This is Stacy Nee McFarlane, aka Sneemac, calling from Old Town, Alexandria, Virginia. My question has three parts, but they're all kind of related. So my question number one is, what is the average rate of hung juries in, let's say, both federal and criminal courts? And does that rate change significantly based on location? And also, what case has been retried the most? I know in federal court, I remember hearing about like a chicken price fixing case that was famously retried 3 times, but it's an old case. Something might have beat the record by now. So that's it. Those are my 3 questions. Thank you. Bye-bye.
Sneemac from Alexandria, Virginia. Thank you so much. Great question. Putting you on the map. All right. I actually found something really interesting that I want to share with you guys in regards to this question, because I didn't have the answers and I thought it was really interesting. All right, how do I do this? Let me share this with you really quickly. I'll get it, Kaylin. Don't worry. All right. Can you guys see that? I'm going to attach this. I'll attach this somehow for you guys. I'll make sure that you guys are able to get a hold of this. But this is from what's called Case Load Highlights, examining the work of state courts. I can't remember what website I got it from, but like I said, I'll make sure that you guys get a hold of this if you want it. It's volume 9, number 1, but it's a profile of hung juries, and it answers essentially, they did an extensive kind of study into answering your questions, Sneemac. And the long and the short of it is, if you can read this right here, it says, compared to the state rate of 6.2%, the federal hung jury trial rate for criminal cases averages 2.5%. So there you go. State, it's 6.2%, and federal, it's 2.5%. I will say that both of those seem very low. I didn't realize they were so low. I feel like just anecdotally, they happen more often than that. And obviously, federal is much lower by, maybe a third even of what the state court is at. And I will say that's not shocking to me either, because the feds are far more careful about the cases they bring to trial and the cases that they actually charge. They will not charge, dismiss many more cases than on the state level. Many times we would inherit cases when I was a prosecutor from the feds that they didn't want to touch it. They felt that they had problems with it. Give it to us. And we go like, this is the best worked up case I've ever seen on the state side. So not surprising that the feds have a much, this isn't conviction rate as much as it's hung jury rate than you would on the state level. Might also have to do with the way the jury selection is done on state and federal grounds as well. But your question as to, does this change location by location? Yes, it does. If you look here, Los Angeles is kind of, pushing the envelope at 15%. Then you get down to places like Fulton, Georgia is less than 3%. So the really fascinating, interesting study that you guys can take a look at on your own time. But to your question about what is the most hung case, I will say I could not find, sorry, what am I doing here, guys? I could not find an answer to that as easy. But what I'll give you instead is a case that I was familiar with that had hung twice before and had been retried for the third time. And this kind of goes to our question earlier about should hung juries come back and should they be considered, should a deadlock jury be considered part of double jeopardy? There was a really, really awful case here in Southern California that had become famous in the DA's office when I was a prosecutor, a case of a man by the name of Cameron Brown. Cameron Brown had, there we go. Cameron Brown had been charged with killing his 4-year-old daughter, Lauren Serene K. Beautiful little girl. This case really bothers me. He had not married Lauren's mother. Apparently it was maybe kind of like a fling or a one-time thing or something like that. And Lauren's mother gets pregnant, has Lauren, and Cameron just really doesn't want to be involved in her life. And he's a very reluctant father, bothered by the idea that he's now been saddled with this beautiful young girl being a part of his life. And one day he's a baggage handler at the airport. And this becomes important because according to the allegations is one day he takes her up to an area here in Los Angeles called Rancho Palos Verdes, where there's a bunch of cliffs along the ocean. And he takes her hiking, a 4-year-old hiking into this area where there are sheer cliffs that fall into the ocean, a place where no one should be hiking, let alone a man and his 4-year-old daughter. And the prosecution allegations were that he took her and threw her over the edge of the cliff into the ocean and killed her. It is the kind of evil that has to be a part of you to do that, is just beyond me. And part of the evidence was, this was back in 2000, by the way, part of one of the evidence was that he then goes down to kind of a beach area that was towards the bottom of that cliff near the water, to be looking for her. And he's kind of making casual comments to people about sunbathers and whether or not they were, had their top off or something like that. In other words, was not behaving as if a man whose 4-year-old daughter had perhaps accidentally fallen off that cliff would behave. In other words, being distraught and beside yourself, trying to rescue your daughter. Awful, awful case. The reason why him as a bag handler obviously played a role is that he was used to heaving very heavy objects, and that was part of the prosecution theory. This case took 3 trials and 15 years before it saw conviction. In 2006, and this is how it hung. It hung 2 people voted for first-degree murder, 8 people for second-degree murder, and 2 for manslaughter. They bring it back again because that's a hung jury. Just because it's hung between different charges doesn't mean that you get a conviction out of it. It's not like you can say, okay, we'll default to the middle here, Your Honor. Comes back in 2009. It's split 6 for second-degree murder and 6 for manslaughter. Again, that's a hung jury. If we're talking about hung juries being acquittals, he would have walked. Even though they wanted to convict him of something, you can't say, okay, we'll take the manslaughter and just be on our way. So they come back again in 2015, and they finally get a first-degree murder against this horrible human being. And I think I got sidetracked on that whole thing because we were talking about hung juries and how often they hang. And this case just always, when we think about just kind of tenacity and bringing a case back as many times as it takes. And I guarantee you, had this case hung again, the prosecutors probably would have brought it back again. The one thing I will say about all of that is a judge can, in the interest of justice, dismiss a case and not allow the prosecutors to pursue it again. So that is just one more kind of thing to consider in these cases. But really awful case if you guys hadn't heard about it, but really demonstrates the real tenacious work of law enforcement investigators and the prosecutors on this case. And I remember that case when they finally got that conviction in 2015. I was still in the office and people were just beside themselves with, relief and congratulations to the prosecutors who had been working on it. Same prosecutor through all those cases. All right. Great question. Stacy, let's keep it going. Just a couple more here, guys. Oh, what did I do? Kaylin, what did I do? All right, I figured it out.
Hey Josh, it's Kathy from Brunswick, New York, aka upstate New York. I'm curious if there's a way to find out what witness holds the record for being the longest witness ever to be on the witness stand. Thanks. Love you. Love Tiff. Love Kai. Love the crew. See you Sunday.
Thank you, Kathy from Brunswick, New York. What I love about these is you guys have a bunch of trivia answers now. Hopefully this comes up in your bar trivia next time, which is the longest witness to ever testify and how often do cases get deadlocked. But thank you, Kathy from Brunswick, New York, pardon me. Let's put you on the map. Longest witness to ever testify. Again, this is one of those things that it really depends, I think, on who's calculating it and who's keeping track. But what I came across is, again, the Charles Manson case. One of the initially co-defendants in that case was a woman by the name of Linda Kasabian. She was part of Manson's family. She was actually present at both the Tate and LaBianca murder scenes. And the government granted her immunity to lay this whole thing out. You could obviously see how important she was. She could connect Manson to his involvement, to the other people who had committed the murder. She'd been present at both crime scenes. She was a very important witness. And because of that, she testified over the course of 18 days. Really long. I think the longest I've ever had a witness on the stand is 3. And that was, at that point, we were like, what are we doing here? So 18 days is a tremendous amount of time to be testifying. So there's the answer to your question, Kathy. Along the way, I did run across what is now recorded as the longest trial. It was a civil trial of Kemner versus Monsanto about exposures to chemicals from a train derailment that lasted for 657 days. So if you think Karen Reed's taken too long, she's not even anywhere close. Kathy says, figures the answer goes back to a case that got me started with true crime as a kid. Yeah, got a lot of people started with true crime. Thank you so much, Kathy. All right, let's keep it going here.
Josh, good evening. Happy Sunday fun day. This is P. Lola's mom. My question is about taking a plea. We see that in the Gardner case, the gentleman that actually did the shooting is taking a plea. At any point, can he back out and say, no, he doesn't want the plea? And then what happens? I know this is a death penalty case. So does it matter if the actual shooter does not say that he was sent there by them? Thanks. Just curious. Happy Sunday.
Pilola's mom, thank you so much. I happen to know from a time you had called before that you are from Mandaluyong, New Jersey. I probably butchered that, and everybody should let me know that I'm wrong. But thank you so much for calling in. Always great to hear from you. Great question. You're asking about the Shanna Gardner case. This was the murder of Jared Bridegan. The shooter in that case was a man by the name of Henry, or is a man by the name of Henry Tenon. He has decided to cooperate with the government and become a central figure, a key witness in that case. There's there he is right there. There is Jared, the man who lost his life tragically, and there is Henry Tenon, who is cooperating with the government. He has entered a plea, but there was a lot of discussion about whether or not he might even ask to withdraw his plea. And so Pilola's mom's question is, can you do that? And how does that work? Yes, you can. You can certainly do it before you've been sentenced. You can always ask to withdraw your plea, but you have to base it upon something. In other words, it can't be just sour grapes, and I don't like it anymore, and I don't want to play along. You have to show that it was based, you entered your plea based upon some sort of mistake. You didn't understand what was being told to you. You didn't understand there was a mistake in what was told to you as the terms of your plea agreement. Ignorance, that you didn't understand. And that you can't just simply base that upon saying, I didn't understand. You have to prove that somehow there was a miscommunication. It wasn't communicated to you properly. The terms of what you were getting yourself into, and therefore you didn't understand. You were ignorant. You did it under duress. Some person was pushing you to do it. Somebody was causing you to do it, threatening you to, giving you false promises, or ineffective assistance of counsel. Your attorneys did not give you the proper information, and therefore you were ignorant, or you did make a mistake, or you were under duress. All of that. It is a good cause. The judge will base the decision on good cause and on standard of clear and convincing. I will say this is rare. Usually the way that a plea is taken, they are trying to avoid all of this. In other words, the pleas are taken in such a way that you are acknowledging you're not making any mistakes. You're acknowledging all the terms of what you're pleading to. You're acknowledging that you've been informed of everything. You're acknowledging that you're not under distress. You're acknowledging that your attorney has effectively assisted you. So you're trying to avoid all of these in taking the plea, and therefore it's very difficult usually for somebody to withdraw their plea. And then to your question of, does it matter in this case if the shooter does not testify in a death penalty case? It's not so much the idea that it's a death penalty case. It's the idea of, how do they put this case together without him? I think they can, but I think it becomes far more difficult, because then the argument being made by the defense that this guy is just acting alone, had nothing to do with it, becomes a little stronger and harder for the prosecution to disprove if he doesn't actually take the stand and say how he was paid and why he was paid and who was involved. So yeah, this case, if you're curious about this case, by the way, we did a case notes on this. Please check it out. We'll share that link. We're going to continue to follow this case. It's a really kind of overlooked case, but I think very fascinating, and it's the crucial part of all of it. The linchpin is going to be Henry Tenon's testimony. All right, guys. Don't be sad, but we have reached our final question of the day. And to bring us home.
Hey, Josh and the Courtroom Confidential crew. This is Sarcasm from Fort Bragg, North Carolina. And I have a question regarding the Stephan Sterns case and the motion to suppress, where they're trying to say that his cell phone was illegally obtained. I've heard all of the audio. I've seen videos. I've read all of the things. And I know that he consented. He gave a verbal consent. But there is one time that I feel like he may have felt like he didn't have a choice.
So I'm actually really concerned about what the judge, how he may rule on this. And if he rules in favor of the defense, that's all the evidence they have is what was obtained through the cell phone on the Google Drive. They haven't charged him with the stuff that they found on the flash drive. So what are your thoughts? What can the DA do if in fact the judge grants this? Thank you so much. I hope you all are having a great, great Sunday. Happy Mother's Day to all the women.
Thank you so much. Oh, pardon me. Thank you so much, Zarcasm. I love your name, by the way. Zarcasm from Fort Bragg, North Carolina. Let's put you on the map. Great question to bring us home with. The Stephan Sterns case. He recently is challenging the search of his cell phone by saying that he wants to bring a motion to suppress it because there was a lack of consent. Let's get to the second part of your question first. And how big a deal is this? You are absolutely right, Zarcasm. If this goes, if the phone goes, I think the entire sex case goes, not the murder, but I think the entire case related to the sexual abuse allegations goes, because you're right. It is all predicated on what was found in that phone. Now, double jeopardy would not apply because he would not have been tried for it. So they could find a way to resurrect it. They could find a way to say, inevitable discovery arguments. They could get a warrant. They get, there's a lot of things they could do. They could also find, apparently there was evidence that was kept on other places other than his phone. Doesn't mean it goes away forever, but it could be catastrophic if this is thrown out to the immediate sexual allegations case. So what do they have to prove there? Well, yes, consent. And yes, if you listen to the interviews, there was consent repeatedly asked for and repeatedly gained. But just to have a little bit of a discussion about consent. When we're talking about consent, we're talking about it's an exception to the warrant requirement. When you're dealing with searches, there's always two categories. Did they have a warrant or didn't they have a warrant? If they had a warrant, totally different arguments. Then it has to do with the sufficiency of the warrant, attacking the warrant, trying to quash the warrant. If they didn't have a warrant, then we're talking about all of the other exceptions to the warrant requirement of the Fourth Amendment. One of those exceptions is consent. You can waive your Fourth Amendment rights essentially by giving consent to have a search done. But the rules are that it must be voluntarily and intelligently given, meaning, again, kind of the same things we were talking about before. It can't be coerced. It can't be it can't be something that you do under duress. You have to understand exactly what you're doing. All of those, I think, would apply here from the consent that he was giving. But to your question, the police do not have to inform you of your right not to consent. This isn't like a Miranda issue or a Fifth Amendment issue where they have to inform you of your right to remain silent. They don't have to inform you of your right to say, I don't give consent. If they say, hey, can I take a look at your phone? And you say, sure, but you didn't know you could say no, that's on you, according to our case law and the Constitution. Your consent is something that is not as the Supreme Court is not as concerned with you understanding the legal ramifications of consent as they are with your own words, your own Fifth Amendment protection. So police can just say, hey, man, can I take a look at that phone? And you could say, sure. And then that's it. They're done. They don't need a warrant. They don't need anything else. As far as the scope, that was an issue here. He's saying, well, I only gave it to them to look at Google Maps. You can limit consent. You can say, sure, you can come inside of my house to take a look at my bathroom, but you can't go into my bedroom. Or when they say, can we come into your home to take a look at your bathroom? Then you could say yes, and you believe that you've limited the scope of that consent to just a search of the bathroom. It's a reasonable person standard. In other words, would an objective, reasonable person standing by, listening to that conversation, believe how far your consent was going? Oh, there you are, Zarcasm. And also the idea of capacity to grant the consent. In other words, you cannot consent to have somebody else's home searched. If I'm just the Amazon delivery guy standing by the door when the police show up and they say, can we go inside and take a look around? I can't give consent to search that home. You have to have a right to use or occupy that property. But that, interestingly, comes down to a reasonable officer standard, meaning if the officers knock on the door and somebody answers and they say, do you live here? And they say, sure. Can we take a look around? And that person says yes. And you find out later that that person did not live there, but was just staying there the night as a house guest. That person may not have had permission to actually grant consent, but according to the officers, they acted reasonably in believing they had been given consent. So there's probably more about consent you ever wanted to know. The tragic case of Maddie Soto, there she is, beautiful young girl. Just these cases with the kids are hard, are really hard. Thank you guys so much for being here today. This was fantastic. Again, incredible questions. We went from Stephan Sterns to Shanna Gardner to Charles Manson to Cameron Brown to Karen Reed to Karen Reed to Karen Reed to Karen Reed. A lot going on with Karen. No wonder, because she's in the news because her trial is taking place. And if you got questions about it, this is the place where you should come. So thank you all for being here. Some quick announcements. If you didn't see it already, yesterday we released our weekly roundup. We talked about, you guessed it, Karen Reed and Gregory Moore and Harvey Weinstein and a bunch of other cases. So check that out. And Diddy and Lori Vallow. So please check out the weekly roundup. It is out already. If you haven't seen it, please check it out. This week, stay tuned all this week. If you want to watch the Karen Reed trial, go to Courtroom Confidential Live Trials, CC Live Trials. Join our entire community in the chat. I've been popping in and out, and I'm going to be trying to do that more because this week is not as hectic as last week, and I'm trying to pop in and give my thoughts where I can and maybe bring you guys some special guests like we did last week to chat over the lunch hour. On Monday, we have a new conversation episode coming out, and we sat down with Kimberlea. She is got a fascinating story, and we talked all about where she came from and how she arrived at where she is today and her incredible YouTube channel. So please check that out. That will premiere tomorrow, Monday at 5 p.m. Pacific, 8 p.m. Eastern. We will be live in the chat, and so will Kimberlea, because she told me she would, and I hope that she will. Check that out tomorrow night, Monday, 5 p.m. Pacific, 8 p.m. Eastern, a live premiere of that conversation with her. And then Wednesday, we have Wednesday Night Live. We are going to bring you a fan favorite, Kevin Fixler from the Idaho Statesman, because we're going to talk about Brian Kohberger, because I don't know if you guys saw the Dateline episode that was released over the weekend. It was 2 hours long, and it was wild stuff. The new information that was released in that episode, I'm blown away. So many new things that we have not heard. And I don't know how they got their hands on it. And they kept on talking about confidential and sources. And so I'm really curious to hear Kevin's thoughts on where all this info came from and how he thinks they got access to it. But really eye-opening, mind-blowing things. Tiffany and I were watching it, and I kept waking her up because she loves to fall asleep immediately as we begin to watch a show. And I kept on waking her up and going, you got to watch this. This is wild. So check it out if you haven't, and we'll be talking about it on Wednesday. As always, the Dateline was explosive. As always, what do I got to share with you here? Go to thecourtroomconfidential.com. Why am I so bad at this? Go to thecourtroomconfidential.com if you want to learn about how to become a member. Guys, I feel like I don't share enough about how hard we work on the membership program here at Courtroom Confidential. Kaylin and Tiffany spend so much time trying to make sure that the benefits that you have of being part of a membership are really worth it. And they do an incredible job. And we add content, and we have live members only live streams every month and videos and giveaways and everything. So please check it out. Go to thecourtroomconfidential.com, click on become a member, and you'll find out about all of those unique opportunities. And click on the shop and you'll find out about all the brand new colors and shirts that we have, including this one. What is this called? Kaylin, what is this called, Tiffany? It's called like strawberry sunburst or something. Crunchberry. This is Crunchberry that I'm wearing in honor of Mother's Day. I love being a member, says Bess Nancy. Well, we love you being a member. Thank you. I love being a member, says Pamela H. It is worth it. Thank you guys so much. Pick up your Crunchberry. What am I doing here? Pick up your Crunchberry. What am I doing here? I'm messing this all up. Your Crunchberry t-shirt, Courtroom Confidential, at the shop today. And then finally, for next Sunday, because we'll be back here again, click on send us a voice message where you can send us your questions and we will answer them as you have just seen live next Sunday. Thank you so much to Afton and Shy Gal, our mods. Thank you to Kaylin and Tiffany for being fantastic and wonderful people. Thank you all for being here with us on a Sunday. Happy Mother's Day, everybody. So glad that we could spend some time with you. This has been fantastic. Thank you all. Appreciate you. Have a wonderful rest of your Sunday.